Hello, hello. Happy marvelous Monday, everybody. I hope that you are well. Listen, I'm super excited that you are joining me for part two on today. Today, we are talking about costly fair housing mistakes that some people make. So, my goal is to help a lot of housing providers avoid some of these costly mistakes. Listen, I am Karissa Spann, the abundantly blessed landlord and tenant expert. This is what I do each and every Monday. I'm live on Facebook, LinkedIn, and YouTube, sharing information to help landlords, tenants, and the entire rental community. So today is all about fair housing mistakes to avoid. All right. If you are a landlord, if you have questions, go ahead and drop it in the comment section. If you are a tenant and you have questions pertaining to the discussion on today, please go ahead and drop in your comments, your questions, remarks, or observations. And again, thank you so much for tuning in. If you find that this information is helpful, please make sure that you are sharing it with other landlords and other tenants, because April is all about fair housing. April is a National Fair Housing Month. Now, this is not something that's new. When it comes to fair housing laws, the Fair Housing Act rather, came about in 1968, and it came about um, to eliminate those people who were being discriminated against. So it's to eliminate discrimination. Now, I get that times have changed, but discrimination has not changed. All right. So I'm going to touch on the 7 federal protected classes. And then I'm also going to touch on some other classes that may have been added depending on which jurisdiction you're in, which jurisdiction the rental property in. But I do want to say that before I get started, that I am not an attorney. I am not providing legal advice. The information that I share, it's the industry's best tips and practices. So by all means, again, if you have questions, comments, remarks, or observations, please make sure that you are dropping that in the comment section. And again, thank you and welcome for those of you who are live on LinkedIn, Facebook, as well as YouTube. All right, so I wanted to just share that disclaimer because I do get questions all the time. Well, Karissa, are you an attorney? I am not an attorney. Okay. I've been in the housing industry for almost over 20 years. I'll put it like that. And so I am so passionate about helping people learn the do's and the don'ts when it comes to residential rental property. So whether that's coaching, training, teaching, all of the above, right? All things property management, I'm your girl. All right, so let me get into it because I have quite a bit that I do want to share today. So last week, I touched on fair housing laws. I shared a few examples. Today is part 2. I'm going to tap in and go a little bit deeper. And I hope that you're taking notes, especially for those of you who are new landlords, new housing providers. Maybe you're new or you're thinking about getting into property management, what you should know about the law. Okay. So let me just tell you that when it comes to fair housing laws, as a matter of fact, let me pull up the protected classes because there are 7 federal protected classes when it comes to fair housing laws. All right. So here are the 7: race, religion, national origin, color, familial status, that means family, sex, and disability. So federal laws protects renters, not just renters, but home buyers. But for the sake of this conversation today, I'm specifically honing in on renters. Federal laws protects renters. Now, although there are 7 protected classes, in many states and local jurisdictions, there are additional classes. So for instance, I'm going to touch on Washington, D.C. because that's where I am. D.C., other states, other cities, other jurisdictions, they have added protected classes. Now, one thing that I want you to know, that nationwide, you're likely going to start seeing more people talk about source of income as a protected class. Source of income protects people who are sometimes participating in housing programs, or maybe they're receiving Social Security or TANF, sometimes a subsidy. And a lot of people don't realize it, a subsidy, meaning that they have a voucher, whether it's a permanent voucher, a local voucher, that is source of income. One of the things that I shared in 2023, I shared a story, true story. There was a large lawsuit. It was a $10 million lawsuit. A company who made a huge mistake. They discriminated against tenants who were participants in the Section 8 Housing Choice Voucher Program. $10 million. Can you imagine a $10 million mistake? That is a bad business practice, all because of what they did not know. Let me just say this, they settled on that $10 million. So that case could have been more than that. And that's a costly mistake. This is why I share information each and every week. And again, April is National Fair Housing Month. So I don't want you to make that mistake if you're a landlord. I don't want someone you know to make that mistake as a landlord, because mistakes, discrimination, it happens. And sometimes it may not be intentional, and it doesn't have to be intentional. But just because it is not intentional does not excuse anybody from violating the laws. So I shared the 7, right? The 7 protected. But in this lawsuit, this $10 million lawsuit, this owner, this management company, they discriminated against people who were in a Section 8 program. And then sometimes you may hear people say, and some of you may have even said it yourself, right? That Section 8 is not welcome in that rental community. They do not accept Section 8 tenants. They do not accept the voucher. That is, in fact, discrimination if in that jurisdiction, source of income is a protected class. If this is your practice, if you know someone who is doing it, please stop. I shared last week that there are testers. There are people who are testing property management companies. They're testing property managers, and it doesn't stop there, right? And I know that sometimes people don't understand the significance of understanding and knowing the law. So just a little bit more about me. I'm a property management educator. I teach property management. And one of the things that I always tell my students is this, especially for those individuals who are just getting into property management. If a lawsuit is filed, if a claim is filed, it's not just against that company, but that claim can include that individual. It could include the company, and it could also include the owners. I'm going to say that again. If a lawsuit is filed, so let me just start at the office level. So let's say, for instance, you have a person, they work in the office, they did something, they violated the law, whether it's a prospect, an applicant, or a tenant. It doesn't have to be a tenant. That's the thing. Prospects, people who have never lived in that rental community, can still file a claim. They can still file a lawsuit if they feel that they have been discriminated against, right? And so let's say, for instance, the prospect called ABC Company. ABC Company said, yes, we have apartments available. Our 1-bedroom start at $2,400. And let's just say, for instance, let's say the prospect said, well, I'm interested. I would like to rent it. I'm in a Section 8 program and my voucher will cover up to $3,800, right? So the original rent, $2,400. The prospect told that property manager that the voucher will cover up to blah, blah, blah. Then all of a sudden, that agent decides to increase the rent, take that rent from $2,400 and shoot it all the way up to the maximum amount of what the voucher would pay. Now, I know that a lot of people have done that. A lot of people are guilty of having done so. I get it, but understand that that is an illegal practice in many places. If your rent is $2,400 and you get a housing participant that comes to you, want to rent your rental property, if you increase that rent to the maximum allowable amount by that housing agency, you could in fact be breaking the law. So please check with your local organizations, your local office in that jurisdiction, or speak to a reputable landlord and tenant attorney who knows and understand fair housing laws. Please do not have these conversations with people who don't know the laws, because things change all the time. And I want you to be abreast of the changes that are here. And in many jurisdictions, it's going to get worse for landlords. I've said it time and time again. I've said it over and over and over. We're going to start to see more lawsuits filed against landlords because they have unknowingly done something which violates the law. And just because you don't know it doesn't mean that you're safe or protected. So please make sure that you treat your business like a business and invest in yourself. Get the knowledge, get the education, get the information that you need to make better decisions with your rental property business and your practices in your business, because that is what will sustain you. I shared how this one company made a $10 million mistake because their staff emphatically stated, "We do not accept the Section 8 voucher." It shut their business all the way down. That was a costly mistake. And so if you have staff and your staff are not aware of the laws, please, I encourage you or your staff, maybe someone who's managing your property, to take a fair housing class. Take a fair housing class to learn what the federal laws are and then your local laws, because there's a lot. There's a lot, and especially in the DC metropolitan area. Now, we know that when COVID hit, it shut things down for many people, many landlords, many housing providers. I understand that when COVID shut everything down, tenants were not being evicted during that time. Now, when the courts opened back up, it created a huge backlog. Some jurisdictions, they started up, the court cases were being heard, and it was a smooth flow. In other jurisdictions, there was a huge backlog, and there is still a huge backlog. So now let's just think, if you will, about the landlord who has not received rental payment. Okay. So they have a tenant who has been in a rental property. They haven't received payment. Then all of a sudden, maybe they've done something. They're hit hard with a lawsuit because they violated fair housing laws. So they're already losing money, then have to come out of pocket to pay money. That is a bad business practice. I don't care how you slice the pie, it's bad. And so please take a class, take a course to understand fair housing laws, because tenants do have rights. Tenants know their rights. And again, it doesn't have to be a tenant. It could be a current or prospective resident or tenant, if you will. I want you to know that and to understand that. So now, last week I touched on steering. Sometimes that happens when, let's say, you have a family who is interested in renting an apartment. Maybe there's an apartment on the first floor and there's another apartment on, let's say, the second, the third, or the fourth floor. And if you're only telling that family about the apartment on the first floor, you are in fact steering them to that unit. That is illegal. That is definitely a prohibited practice. You could definitely get yourself in a lot of trouble if you are doing that. Please do not steer people. Last week, I touched on disability. Now, let's use this same scenario where you have a rental apartment available on the first floor. you have another apartment available on the second or the third floor. Let's say you have an applicant who comes to you, or maybe they call you, they say, hey, Mr. and Mrs. Landlord, I'm interested in your rental property. I saw the pictures online and I would like to come and take a look at it and possibly submit an application. You said, oh, well, thank you so much. Yeah, let's schedule an appointment for you to come. And they get there, they're in a wheelchair, and you only direct them to the first floor unit. If you have other units available, please make sure that you are telling them about everything that you have available. Because if not, that is also steering. You are not allowed to make decisions on behalf of others. Allow people, if that is your business practice, right? You have multiple units and people are able to choose, allow them to choose, never choose for them. Now, if you're managing a rental property, let's say, for instance, if you're in a tax credit property, or you manage or you own a tax credit property, you definitely want to fill the unit that has been vacant the longest. All right. That's the best business practice. You want to fill that unit that's been vacant the longest, because you should be running reports, or reports should be generated so that you'll know how much revenue you have lost. So you want to backfill those vacant rentals first. So those are just a few things, but let me also share some additional prohibited practices, because again, what you don't know can and will hurt you. So let me go back to disability status. And this is one of the scenarios that I've shared with my students in class recently. So here is the example. You have a prospect comes to you over the phone. They say, hey, I'm interested in your rental property. Can I come out on Saturday and take a tour? You say, well, yeah, sure. Mr. and Mrs. Prospect, Miss Prospect, I love to show you this vacant rental on Saturday. And they say, well, I'm in a wheelchair. I won't have any help. I'll be getting a ride share, maybe Uber or Lyft, and I'll need some help getting out of my wheelchair. Now, for many people who do have a heart, who do care about people, sometimes you may think that it's good to help out. Sure, we can help you out of the wheelchair. Let me just pause and break this down for many of you. Some of you may not see anything wrong with it, but that is also something that you do not want to do. Here's why you don't want to do that. You having a good heart, a kind heart, could potentially do something that would injure that individual. And then you find yourself in a situation where they're trying to sue you. So always let them know, we would gladly schedule the appointment for you to come and take a tour. Unfortunately, we are not able to help you get out of the vehicle. And you put that back on them. Let them know that you are available. Let them know that the apartment or the rental property is available, but do not offer assistance to physically help someone who is disabled. Because if you do something, we don't know how that's going to turn out for you. So don't put yourself in that type of situation. All right. I shared last week that when people share or they tell you that they are disabled, as a housing provider, you can never, ever ask them why they are disabled. You can never, ever ask them what is the disability, because a disability can be a physical or a mental impairment. Just because a person does not walk with a crutch, a walker, or in a wheelchair, or have a cane, doesn't mean that they are not disabled. So please never, ever, ever do that. Now, here's another thing. Here's another prohibited practice. So let's say you have a pet-free community. Oh, we have no pets in our rental community, right? I know a lot of people who have no pet communities, no dogs, no cats, no anything. And you have a tenant or prospect who say, well, I don't have a pet, but I do have an emotional support animal, or I have a service animal. Here is what I want you to know. If that is the case, you, Mr. and Mrs. Housing Provider, cannot charge tenants a fee for emotional support or service animals. That is against the law. They're not pets, so you can't charge a pet deposit. You can't charge a pet application fee. You cannot charge a monthly pet amount. You cannot do it for service, emotional support, or service animals. So if you are doing it, and I know that a lot of people are, because I've had conversations with many people, you cannot charge tenants for emotional support or service animals. You can make it your policy to make sure that they provide the documentation for that animal, meaning that they have a certificate from their medical provider, and you can also require shot records, vaccination records of that animal, but you cannot charge them any money. I know that's heartbreaking for many of you because I've been getting emails about it. So I wanted to publicly share this. If this is your policy, I know some of you, it is your policy, please don't do that. Because if the tenant finds out that you're doing that, you're charging them money for an emotional support animal, they could sue you. Okay? So please don't do it. Give yourself a slap on the hand now. Mistake made in the past, but not in the future. All right? When you know better, do better. So now you know. I wanted to share that. All right, so let me go to another protected class. So I see some of you are on here in the DC area. So when it comes to sexual orientation, you cannot discriminate against a person because of their sexual orientation. Also, now this is for Washington, D.C. Now, if you're watching in another jurisdiction, please check to make sure that this is or is not a protected class in your area. So I talked about sexual orientation. Let me also touch on personal appearance. You cannot, in Washington, D.C., discriminate against somebody because of how they look. You cannot discriminate. You cannot deny housing. You can't even tell them that you can't lie and say, oh, well, it's not available. I had a young lady who she's married to a female. When she called to schedule the appointment for the tour, she said, me and my significant other, we're coming to look at the apartment. I'm sorry, it was a house. So when the young lady got there, she met the landlord at the door. She was getting ready to go, and she says, oh, let me go get my significant other. I'll be back. The significant other was sitting in the car. So she went to the car. She got her wife. She came back. Hey, this is my wife. Right? She think that they're getting ready to go in and see this property. Then all of a sudden, the landlord conveniently remembered that, oh, you know what? I apologize. Someone put an application on this and it's no longer available. Keys in hand, getting ready to go into the house to show them the place. Then all of a sudden, when she realized she's married, same-sex marriage, she conveniently remembered, oh, it's not available. And so the young lady, she reached out to me. I told her that wasn't in fact discrimination. And it turned out really, really bad for that owner because she didn't know, right? Whether it was intentional or not, the laws don't care about how you feel, what you think should happen. The laws are in place to protect people. I talked about disability. I talked about source of income. I talked a little bit about familiar status. I talked about steering. And one thing that I want you to understand when it comes to steering, sometimes you could really intend to do well and mean well. So for instance, let's say you have someone, let's say you manage or you own multiple apartment buildings, and you in conversation tell an applicant that maybe they should go to a specific building because it's quiet there, because maybe there are no kids, or maybe that is the building where there's less smoking of marijuana, right? You know that marijuana is a thing. And you have a let's say an elderly person, someone who's up in age, They want to rent, and you really want to do the right thing by just making sure that they're in a place that they could really enjoy calling home without any issues. Please do not do that. That is against the law. And you can mean well, you could intend to do good and still be breaking the law. And I know that for some of you, this is like just mind blowing, like it just doesn't make sense. You're trying to do the right thing, which is why you need to understand the laws. So I'm glad that you're tuning in. And for those of you who are watching the replay, I'm glad that you're watching the replay. So when it comes to advertising your rental property, let me touch on that for a little bit. When it comes to advertising, I know that for many of you, if you're not versed, you're not professional in advertising, you may put things out there that could potentially hurt you and you don't even know it. So one of the things that I like to say when it comes to advertising your rental property, advertise the property. Don't focus on people. I know that sometimes people will include pictures. If it is pictures, make sure that it is an all-inclusive picture of multiple colors, male, female, black, white, brown, right? If you are including people, include a diverse range of people. One of the things that I always like to say is that when it comes to advertising, you would only hear me and see me advertising running campaigns that will specifically show the property. I'm not showing people because you not knowing could include a picture that excludes a specific color, a specific category, a specific protected class of people. You don't want to do that. There are fair housing testers out there. That is their job, to test landlords. They're going to look at advertising. They're going to call over the phone. They're going to visit in person. It is their job. I show students in my class, I show them how to shop the competition. So that includes calling. How are you greeted over the phone? Were they warm? Were they welcoming? Did they greet you by name when you show up at the property? How did they receive you? And I tell my students, be creative. When you get there, tell them whatever, make up any type of story. Like I coach students how to do this. But for some, the testers, this is their job. They're going to ask. Now, here's the thing. I think I shared last week. I think it was last week I shared how I believe there were some testers who came to a property of one of mine. And because I teach this and I talk about it, I kind of recognized it because they ask the same identical questions. So if you're going to have a situation where testers are coming to you, the people, they're going to ask the same question, but they're not going to look the same. So you may have a Spanish couple, you may have a white couple, you may have an interracial couple, you may have young people, you may have old people, right? They're not going to look the same, but they're going to ask the same questions. They're going to have the same type of situation because the testers are comparing apples to apples. They're going to have the same preference of apartment. They're going to have the same preference of income. They're going to have the same preference of the date that they're moving in. They're going to have the same or similar preference of amenities, things that they want, things that are seemingly important to them. They're going to ask you the same questions. And if you answer the question one way for let's say tester A, let's say tester A wasn't your cup of tea. You wasn't feeling tester A. Maybe they came in smelling like weed, but they had good credit. Smelling like weed, had good credit, pants were sagging. A female and a female. And then you have another tester who comes in, a white male, asks the same questions, dressed professional, right? You have to be very careful that you're saying the same thing and you're treating everybody the same way. So please make sure that in your advertising, you are not putting anything in your advertising campaign. For instance, great property for single women or single females, or great property for single men. That is discriminatory. Unless you have a contract. with some sort of organization and you have a specific category of housing. So let's say, for instance, if you have senior housing or if it's for 55 and older, right? Then that would be okay. But if that's not the setup, then please don't put that in your advertising and please don't tell people that, because that is a prohibited practice. You cannot provide different housing or different units for different classes of people. You can't do that. That is a prohibited practice. And I'm still talking about fair housing because that's considered discrimination. And so these are just some examples of illegal discrimination. Don't persuade people to let's say, move into a specific neighborhood. Let's say you have, for those of you who are in DC, let's say, for instance, you have property in Anacostia, but then you may also have property in 16th Street Heights or Columbia Heights or Petworth. Don't persuade people to go to a specific area of the city. That's illegal. That's illegal discrimination. Don't refuse to accept an application because you look at someone. Let me go familiar status. So you have a family that comes to you. You have a single mother. She brings her 3 rowdy children whose behavior is maybe not the most desirable. Okay. And they're taking a look at the rental property, and you notice that the children are just running around, just out of control. They're just screaming. They got their hands all over the wall, right? And you tell them that they can't rent the property, maybe because you just don't like the behavior of the kids. And let's just be honest. Call a spade a spade. I'm gonna just shoot straight down the middle here. Call a spade a spade. Sometimes you can see the behavior and know that I don't really care for this behavior. Or maybe the behavior might rub you the wrong way, right? If the behavior seems out of control. You cannot discriminate based solely off of that. Also, you cannot, when it comes to the application process, in DC, and a lot of jurisdictions are starting to do the same thing. You cannot solely refuse housing to people based off of their credit score. This is in DC, and a lot of jurisdictions are starting to follow suit. So let's say, for instance, I get it. I know. I just saw the text message come in. You cannot discriminate based solely off of the credit score in Washington, D.C. You can't do it. Now, you can make that part of your application process, but that can't be the sole reason that you are declining applications. Now, let me add this last point when it comes to the application process. Please make sure that when you are denying applications, that your communication with that applicant is as such. You're not denying people, you're denying the application. And if you are denying the application, you are required to provide them with an adverse action letter, a denial letter. Refer them to the credit bureaus. But if they're asking you to provide documentation to justify why that application has been denied, you are required to provide that information. In many jurisdictions, you're now going to be required. I know that many of you have been doing that. You've been providing denial letters, but listen, I know quite a few people who have not done it. So you always want to document, because you don't want to claim filed against you for seemingly discriminating. So if you deny an application, please document the file. And if that applicant is asking for a copy of whatever you use to make that determination, you're required to provide that to them. One of the things that I like to share is this. I always like to direct people to the credit bureau. I'm not personally conducting a background check. I'm going to always use a third-party service provider to conduct that background check. And on that letter, that adverse action letter, it's going to have information to that credit bureau so that that tenant, or the applicant rather, could contact the credit bureau to resolve the issues. Never try to explain anything that's on that credit report to them. Let them contact the credit bureaus, because unless that's your specialty, sometimes people make the mistake trying to explain something that they don't really understand. Provide that applicant with that information to the credit bureau and let them work that out. All right. So those are just some things I wanted to touch on today. I wanted to share that because April is all about Fair Housing Month. Now, I know that in many jurisdictions, things are not always the same, meaning that some of the protected classes that I covered today, which is specific to DC, it may not be applicable, or maybe there are others. And in DC, there are a lot of other protected classes that are included. And if you want more information in the Washington, DC area, I would strongly, strongly recommend that you contact DC government, DC Human Rights Act. You can find out all that information, DC Human Rights Act, and there is a much longer list of what you cannot what you cannot do. The protected classes that covers renters as well as those who are purchasing a home. And I hope that you have taken some notes. If you want more information, let me know which jurisdiction you're in, and I can provide you a listing of some places in your jurisdiction. So whether you're a landlord or whether you are a tenant, if you have questions pertaining to the fair housing law and the protected classes, please email me and I will reply back with a link that will take you to your jurisdiction. Hey, Mr. Bell, thank you so much for tuning in. I am Spantastic today. Thank you so much, as always, for tuning in from YouTube. I see YouTube coming in. Hey, thank you so much. You said New York have source of income. Wow. That's a good thing. That's a good thing for tenants, but it's a bad thing if there's discrimination. So in New York City, we have source of income discrimination. I had a landlord say that it was required every tenant make at least 2.5 times the rent for income, but then we wouldn't be okay for Section 8. That is a problem. That's a problem, because let me put that back up. Section 8, any housing subsidy program is considered a source of income. And so if you have someone who you feel has violated your law, has violated your rights, violated the law, I would definitely consider checking into that a little bit more. Speak to a landlord and tenant attorney or an advocate who can help guide you in that situation. But that may be discrimination. Yes, and usually, and here's what I had a call I was on last week, a group of landlords. And so some landlords don't really understand all the do's and the don'ts. Now, ideally, you do, as a housing provider, want to tell every applicant who comes in what your application process is. And yes, you do want to make sure that people can afford to rent your rental property. But if they are getting assistance from the government to help them pay their rent, then please don't tell them that they're required to have at least 3 times or 2.5 times the amount of rent. Okay. Although that is your practice and you don't want to discriminate. I had some landlords on the call that I was on, they didn't understand that. They said, well, isn't that discrimination if we only tell that to Section 8 people, or we don't tell that to Section 8 people? Isn't that discrimination? Because they want to make sure they're telling everybody the same thing, right? So this is why it's important to know the do's and the don'ts, what you can and cannot do, what you can and cannot say. So source of income is definitely something that a lot of jurisdictions have now started to take on, because they recognize that people have been discriminated against because they have a Section 8 voucher. Now, let me just also say this. I see you, Mr. Bell. I'm coming to your comment. Then let me just say this, that as a housing provider, you have rental property and you have people, let's say you have an applicant and they're interested, they are in some sort of program. Let's just say they're in a Section 8 program, but maybe they did not meet you conducted the background check and their application was still denied. You can deny the application as long as you have a legal reason. So the law is not saying that you must absolutely ignore everything just because a person is participating in the voucher program. But the law is saying that based off a protected class, you cannot just automatically discriminate or automatically deny or reject because they're in some sort of housing subsidy program. All right, Mr. Bell, you tried to apply for disability housing. The management takes disability, and the owner said we don't take disability. That's a problem. That's a problem. And so if you're applying for housing and you're told one thing, but then when you go back, you're told something different. Now, I think I might have been a little bit confused here. Was this the same property? Because sometimes you can have an owner, you can have a property manager. Maybe the two are not connected. So is this the same property that this happened at? Because that might be discrimination. Or maybe it could have been somebody new, and maybe they didn't know what they can and cannot do, what they can and cannot accept. But I would definitely say explore it a little bit more, ask questions. Listen, here's the one thing that I do understand. We have not, in many cases, because we ask not. We're not asking we're not asking the right questions, right? Everything is not always the same. Okay, I see your comment, Mr. Bell. Thank you so much. Everything is not always the same. Now, things may be similar, but they're not always the same. So ask questions to understand the process. It is okay as a tenant. It is perfectly fine and okay to ask the landlord their application process. Hey, what is your policy? What is your application policy? How long does it take to process the background check? Do you automatically reject or decline applications for people who are in Section 8 or rapid rehousing or the VAS program, or whatever program you're in, the disability program, whatever program you're in? Ask those questions. Ask those questions up front. And if you're not sure, ask them if they could clarify. Hey, well, I know that you said this, but can you clarify, like, what does that mean? Ask them about their security deposit policy. Are Section 8 tenants required to pay a higher security deposit versus someone who's not in the Section 8 program? That's discrimination. Ask those questions so that you'll know and have a clear understanding. Because again, it is a business. And here's the thing. It's not what we know, is what we can prove. And just because you think it could be discrimination, and in fact, it might be, it's not what you know, is what you can prove. And so if you can prove it, then at least you have a leg to stand on. But if you cannot prove it and you just going off of, oh, well, I saw Karissa on YouTube and she said that this might be discrimination, so I feel like you're discriminated against me. Maybe they are, maybe they're not, but you want to be able to prove it. Okay, Mr. Bell, the task program said that they do. Okay, so what I would definitely suggest for you is to speak to someone in your jurisdiction. Mr. Bell, you're in New Jersey. Remind me of your jurisdiction. Where are you tuned in from? Because if I can get you some help in your area, email me and I will respond to your email. Okay, great question here. How do you bring up source of income discrimination without burning bridges, or do you just go make a complaint, especially if you don't know them? That's a great question. And so if you feel that it is source of income discrimination, here's how you know it. They say if you're in the Section 8 program and they tell you that they don't accept Section 8, that's discrimination. Okay, if you, okay, Clifton Park, New York. Okay, so if you have, let's say you have a fixed income and they tell you, let's say the rent is $1,000, and typically your income, if you're a market tenant, you should always have an income of at least 3 times the rent amount. So if the rent is $1,000 as a market tenant, you want to make sure that it is affordable for you. I would say stick to around that 30% range. So that means your income should be $3,000 a month. But if you have some sort of housing subsidy, or you are on a fixed income and the landlord tell you that they can't rent to you because you have Social Security or because you have TANF, which is welfare assistance, right? Or you have some other source of fixed income. That could be income discrimination. But how do you bring up that conversation? You first understand their application process. That's why I said you want to ask the questions up front. So as a tenant, I would always recommend to ask questions before you give answers. For instance, let's say, let me come to you, Mr. Bell. You're in Trenton, New Jersey. You're a landlord. I want to rent your property. I want to rent from you, Mr. Bell, because you are a new landlord. I've seen your property online. I like the pictures and it looks nice. So, Mr. Bell, I'm going to contact you as a tenant. I'm going to ask you, hey, Mr. Bell, what is your application process? Do you have an income, Mr. Bell, do you have an income requirement in order to live at your rental property, in order to live in your house, Mr. Bell? Do you have an income requirement? Or what are the requirements to rent or to live here? You want to ask those questions to understand what is being required. Okay. And then if you're participating in the housing program, you can go through the process. Well, I would like to complete an application. Is there an application fee? Is there a requirement for me to pay the security deposit? How much is the security deposit? How soon can I move in? Ask all these questions up front. Then you can tell them you want to move forward with the application process, but you want to understand how to make the payment. So let's say, for instance, the application fee. Are you required to pay by money order? Are you required to pay online with a credit card only? You want to ask those questions so that you know up front. Okay. And then you move on to completing the application, understanding what is required of you. Okay. Ask those important questions. Absolutely. And then at the point of you submitting that application, if the landlord all of a sudden switch up, understand what's going on. Why is there a switch up? Is the place available or is it now no longer available? You told me that the application fee was $25 and I told you that I'm in a Section 8 program and now all of a sudden the application fee is $50 or $75. You told me that the rent was $1,000, but then when I told you that I'm in a Section 8 program, the rent has now gone up to $3,000. You see where I'm going with this? And so how can you prove something you don't know unless you ask the questions up front? So always ask questions up front. All right. So landlords, housing providers, I hope that you're taking notes. Hope that if you have staff or if you have someone who's managing your property for you, please make sure that they understand fair housing laws, because I shared a little bit earlier, for those of you who were on, I shared how complaints and lawsuits, when they come in for fair housing discrimination, it's not solely on the owner. It's not solely on that property management company, but sometimes it's going to be the leasing agent, the leasing professional, the property manager, the company, the owner. They're going to go up the line. They're not going to just start up and just go with that one person. Okay. So I hope that this was helpful. Let me share my email address. And Mr. Bell, I want you to email me. Any of you, if you have questions about fair housing laws, protected classes in your jurisdiction, that's my email address at the bottom of the screen. Please email me. You can find me info@landlordlyfe.com. This was part 2 Part two, costly fair housing mistakes um, to make, or not to make rather, right? So April is all about Fair Housing Month. I hope that this was helpful. I hope that this was of value to you. Please make sure that you share this with somebody. And again, if you have questions, please email me. And if you have not already subscribed to that YouTube channel of mine, please find me on YouTube. I'm at Landlord Lyfe. Lyfe is with a Y. Landlord Lyfe with Karissa Spann. There you can find all of my replays. Smash that subscribe button so that you'll be the first to know when I am live and online. This is what I do each and every Monday. I'm live right here on Facebook, LinkedIn, and YouTube. 7:30 p.m. Eastern Standard Time, sharing information for tenants as well as landlords to positively impact and improve rental communities. I absolutely love what I do. I thank you for your time. My time is up. And I appreciate you and yours. I hope that you will tune in next Monday right here, same station, same time with me, Karissa Spann, the abundantly blessed landlord and tenant expert. And so today was all about fair housing and costly mistakes that landlords should not make. You want to definitely avoid these prohibited practices. You want to know and understand what the laws are. If you have not taken a fair housing class, please find one in your area and take a fair housing course. If you have someone managing your property for you, please make sure that they know and understand fair housing laws. And I know that in many cases, in a good book that I read, it talks about how the blind leads the blind. Well, this is not the business of the industry to get in where the blind is leading the blind, because you will likely end up going down a rabbit hole together very quickly, and it could be a costly mistake. I shared how one landlord, one company, they settled on a $10 million lawsuit that was filed against them for fair housing discrimination. Don't let that be you. Join me next week, next Monday, right here, 7:30 p.m. Eastern Standard Time. I appreciate you all. See you then.